Why the Finnish court sentenced Simon Ekpa but did not ban IPOB in Finland. In a landmark ruling that has reverberated across globe, the Paijat Hame District Court in Finland sentenced Simon Ekpa, a controversial Biafra agitator and self-proclaimed Prime Minister of the Biafran government in exile, to 6 years in prison on September 1, 2025. Ekpa, a Finnish Nigerian citizen who has resided in Finland since 2007, was convicted on charges including participation in a terrorist organization, incitement to terrorism, distribution of weapons and explosives, and tax fraud. The swift trial, which began in late May 2025 following his arrest in November 2024, concluded in just 9 months, a stark contrast to the protracted legal battles surrounding similar figures in Nigeria. The verdict has sparked widespread debate, particularly among supporters of the Biafran self-determination movement. Ekpa's activities, often conducted via social media from Finland, have been blamed for escalating violence in Biafra. However, while the court held Ekpa personally accountable, it notably refrained from extending its judgment to IPOB as an organization by imposing a ban or proscribing it in Finland. This decision raises interesting concern about the Finnish judiciary's approach to international freedom movement, freedom of expression, and the distinction between individual culpability and organizational legitimacy. From information Family Writers Press International gathered, we are going to meticulously explore the reasons behind this nuanced outcome, drawing on the court's reasoning, legal precedents, and statements from IPOB itself. Simon Ekpa emerged as a polarizing figure in the Biafran agitation. The Biafran movement traces its roots to the Nigerian Civil War, 1967-1970, where the southeastern region sought independence after incessant killing of Igbo people, majorly Christians, who lived in northern Nigeria. The War of Separation resulting in over 3 million deaths, mostly children. Biafra agitation revived in the 21st century under leaders like Nnamdi Kanu. IPOB advocates for the restoration of the Republic of Biafra through nonviolent means, including referendums and international advocacy. IPOB, designated a terrorist organization by Nigeria in 2017, maintains it is a peaceful group committed to self-determination. Ekpa, however, positioned himself as a rival leader, claiming the title of Prime Minister in Exile and promoting a more militant autopilot group. From Finland, he used platforms like social media to issue directives, including calls for armed resistance and the procurement of weapons, which Finnish prosecutors linked to violent incidents in Nigeria between 2021 and 2024. Ekpa's defense argued that evidence from Nigeria was unreliable and that he was merely a content creator, but the court, in collaboration with Nigerian authorities, deemed the proof overwhelming. The sentencing demanded by prosecutor Samsa Hakala and upheld despite appeals from Ekpa's lawyer Karla Gummerus focused on Ekpa's personal actions as a Finnish resident. Yet, the absence of any measures against IPOB has fueled speculation. Why did the court stop short of banning IPOB? A pivotal factor in the court's decision appears to be IPOB's repeated and emphatic distancing from Ekpa. It was also learnt that IPOB's Directorate of State, DOS, previously has submitted numerous petitions to Finnish government against Simon Ekpa and his violent activities, distancing the IPOB movement and its leader Nnamdi Kanu from Simon Ekpa. IPOB has long positioned itself as a non-violent movement, emphasizing logic and superior arguments over armed struggle, as articulated by Kanu. This aligns with international norms, where violent agitation is often viewed as a violation of law, while peaceful advocacy for self-determination is protected under human rights frameworks like the UN Charter. The Finnish court, in its judgment, targeted Ekpa's individual role in a terrorist organization, but did not classify IPOB itself as such, likely because IPOB has not been implicated in any specific crimes. As one ex-post analyzing the ruling stated, the Finnish court judgment IPOB unstained, underscoring that the conviction was personal and did not taint the broader organization. By treating Ekpa as a rogue actor rather than an IPOB representative, the court avoided broadening its scope, preserving IPOB's operational space in Finland for peaceful activities. Finland's legal system, rooted in civil law traditions and EU directives, requires a high threshold for banning organizations. The Finnish Criminal Code addresses terrorism under Chapter 34A, which penalizes participation in or incitement to terrorist acts, but proscription of groups demands evidence that the entity as a whole engages in systematic criminality. In Ekpa's case, the prosecution focused on his direct involvement, such as using social media to encourage violence and facilitating arms distribution, without extending charges to IPOB's leadership or membership. The court asserted jurisdiction based on Ekpa's residency and the crimes commissioned from Finnish soil, but it did not find sufficient grounds to deem IPOB a terrorist entity under Finnish law. Banning IPOB could have been seen as overreach, especially since the group operates diaspora branches in Europe focused on advocacy, not violence. Legal experts have noted that Finland's swift handling of Ekpa's trial, compared to Nigeria's ongoing Kanu case, reflects a commitment to due process, but without compelling evidence against IPOB, a ban would violate principles of proportionality. Family Writers Press International.